well, since 1948, commissioners of care, whatever we've called them, have had a duty to promote a comprehensive health service, and lawyers always point to the fact that the word promote is different from the word provide. So it's a target, it's an aspiration, it's something we're aspiring to, but it doesn't impose any particular duty. In addition to that, the word comprehensive is not defined in the acts governing the NHS. And what that means is that there's a huge discretion which is given to individual commissioners, presently PCTs, to decide what is most suitable for their local populations. And the way we manage that problem in the South Central, and the 9 PCTs working in the South Central, is by means of the South Central Ethical Framework and the South Central Priorities Committee, which makes decisions about the sort of treatments that we can afford and the circumstances in which they should be made available to patients. So that sits alongside the recommendations of NICE.
Right, and can you just explain to us how commissioners can avoid going to judicial review?
Judicial review is a remedy which normally enables patients to challenge the procedures on which decisions have been made rather than the actual conclusions of those decisions. And it means that commissioners ought to have proper procedures in place to demonstrate that they have considered all the various relevant circumstances, they've not considered irrelevant circumstances, and given those circumstances proper weight. And that's what we hope we achieve in the South Central system, which uses, as I say, the priorities framework that we introduced some time ago.
Will anything change when GPs start commissioning?
It's a good question. In one sense, things simply can't change. We have to introduce austerity measures which will not increase the sum of money available for the NHS. So the need to prioritise, to ration care, will exist every bit as much, even more, than it does now. So yes, that will continue as it goes on now. And there's just a legal issue that may need to be resolved, and that is, since 1948, when the first General Medical Services regulations were introduced by NIBEVAN, there's been a general duty placed on GPs to prescribe the medicines and treatments that are needed by their patients. And that duty continues to exist now, whether it's the GMS regulations or the PMS regulations or indeed the APMS regulations, that duty still exists. Now, so long as that duty continues to exist under the new system, then there is this tension between the, as it were, the needs-based, the Hippocratic duty which those GMS, PMS regulations place on GPs, and at the same time, the inevitable duty to prioritise treatments in order to make resources last the entire financial year and not run out of money by, well, the 9th month of the year, for example. And there's that tension. So far as current PCT commissioners are concerned, rationing is lawful. And so far as GPs are concerned, they should prescribe on the basis of need. And if there's any tension between those two things, because PCTs are not GPs, then there's a way, or one way or another, in which those tensions can be resolved, although it's not free of difficulty. But you can see that there is an added difficulty if GPs become the commissioners.
So legally, how do you think that tension can be resolved if the law is not changed?
It's another good question. I suspect that tension is not going to be resolved so long as we have this duty. It's an odd thing, in fact, that although this duty has existed for all these years, there's been very little litigation, only one case that I'm aware of that's ever challenged the meaning of this needs-based duty to prescribe that's based on GPs. One might have thought that it would have attracted more attention and more litigation. So it may be that there are ways of interpreting that duty, that needs-based duty, that that dilute the Hippocratic nature of it and turn it into a more community-based duty. But as it stands, there is this tension. And I think that tension will ultimately need to be resolved, either by altering the regulations, and I must say, I think GPs might legitimately resist that because they might wish to stand on the side of patients in advocating for them in respect to the treatments they say they need. So either we keep it and it ends up being the matter of subject of litigation, or alternatively we change it and introduce new regulations.
In your opinion, do GPs understand the scale of the task ahead with regards to prioritisation?
Well, there are two things. I think the first is simply their training and their expertise has been essentially clinical and Hippocratic. And although I'm sure GPs recognise the need for priority setting, it hasn't been their business. It hasn't been their major concern. So for many, there may be a change of mindset, a change of attitude and approach to a much larger community-based enterprise, which is rather different from their patient-based duties that we were discussing a moment ago. And the other thing is the extent to which, in any case, GPs are engaged with this process, the process of priority setting generally. I don't know, but I suspect many have been perfectly comfortable to leave this unenviable priority setting duty to the commissioners, to the PCTs. So, I would suspect that for those reasons, many GPs are neither sort of prepared for it nor have the experience of it. On the other hand, one suspects that it's a skill that they will acquire rapidly. But so far as there's been discussion of, as it were, GP commissioning, I think to hand these serious and very weighty responsibilities to GPs alone would be, well, frankly, ludicrous. It's a much broader base of skill and expertise and experience, including those of patients and the public, which is required to do this in a responsible way.